now about to wrap up our day, and it's my pleasure to introduce our keynote speaker telling us about the future of law and neuroscience. The Honorable Jed Rakoff is United States District Judge for the Southern District of New York, but not just a judge, a prolific author and thinker, and really a thinker very carefully at this intersection of law and neuroscience. He served on the governing board of the Law and Neuroscience Project, which was started in 2007, and has seen this field emerge, and really there's no one better to think and help us think about where it's headed. So I give you the Honorable Jed Rakoff to talk about the future of law and neuroscience.
So for all of you who are still here, you have my admiration for your bladder control. I need to, at the very outset, make a couple of disclaimers. First, I'm forbidden by federal law from commenting on any pending case, not just before me, but before any court in the United States. And secondly, I am forbidden, again, from commenting on any issue that is likely to come before me for decision in the immediate future. So that concludes my remarks. Thank you very much. I have to mention also that I've been truly inspired by the fantastic presentations today, and by the work of the MacArthur Foundation. I was so inspired that over the last break, I decided to conduct a survey on the hypothesis that Liz Phelps had put forth that judges are human. So I first asked the three judges at my table, and by a 2-to-1 vote, they said judges were human. But then I asked a random sample of 3 lawyers, and they were quite unanimous that judges were inhuman. Lastly, along those lines, several years ago, I conducted a more serious neuroscience investigation. I was down in Washington, and I took the fMRI scans of all 9 justices of the Supreme Court. I was able to do this because they were half asleep. They were reading briefs. It turned out that 4 of the justices of the Supreme Court are entirely missing the right hemisphere of their brain, and 4 of the justices of the Supreme Court are entirely missing the left hemisphere of their brain. And there's one and only one justice who has both, but the connections are very weird. So to get serious for a minute, my point is that not all neuroscience research is as good as what you've heard about today. And the problem that a judge has is how do you deal with it? This is not an area judges are familiar with. There's also been a history, a rather unfortunate history of how judges have been too accepting or too fooled by what passes for brain science. And I'm using brain science now in a very broad historical sense. But the first brain science to enter into the legal system was phrenology. Back in the 1830s and 40s, you will see, if you look, there are quite a few reported cases dealing with phrenological evidence. This is evidence about how your brain works or how your personality is revealed by the bumps on your head. There's a case, for example, called Forer v. State, an Ohio case in which a Ohio Court of Appeal overturned a conviction holding that the evidence that had been presented, the phrenology evidence in that case, showed conclusively that the woman who was convicted of murder in that case was insane, and that therefore she should have been acquitted as a matter of law because of the bumps on her head. Well, you can say, okay, that was the nonsense of that early period, but think about the early 20th century when the rage was eugenics. And there was many a scientist who said that all sorts of characteristics, mental states, and so forth could be inherited in a very direct and provable way. And on that basis, many women were, with court approval, sterilized. And the issue finally went to the Supreme Court of the United States, where in the famous case of Buck v. Bell, the Supreme Court in 1927, in an 8-to-1 opinion authored by no less than Oliver Wendell Holmes, said, absolutely, this is good science. And he was always good with a quip. He said, 3 generations of imbeciles are enough. Those of you who've looked into that case will know that, in fact, the evidence actually strongly suggested that there were 0 imbeciles at any of the generations involved. But that's a different point. The point was that this pseudoscience was accepted by the courts as good science, and it really wasn't until it was adopted by Hitler as his favorite science that it got a bad name. And then, in the 1940s, there was the whole rage of lobotomies, where the scientific assertion was that you could deal with severe depression by removing parts of the brain. And some of these were done without court approval, done voluntarily, that is to say, by parents forcing it on their kids, the most famous being Jack Kennedy's sister, Kathleen, who became a vegetable as a result. And some were approved by the courts. There were something like 70,000 lobotomies performed in the United States between 1940 and 1960, after which they were discredited. And then also beginning in the 1950s, there was an infatuation by some of the very best judges with psychoanalysis. The Durham test, the test for insanity that became the leading test till the Hinckley case, was promulgated by Judge Bazelon, a very excellent and famous judge on the D.C. Circuit, based on his total love at that point with psychoanalysis, which he later wrote that he very much regretted. The test, as you know, and it still is the federal test, although not the test in many states, is you are insane, or at least not culpable, if your act was the product of a mental disease or defect. And it was left in those days, to the psychoanalyst to determine what was a mental disease or defect. More recently, it's determined largely on the basis of the so-called DSM, which is now in its 4th edition, about to come out on the 5th edition, and which is the Bible of many psychiatrists and psychologists in analyzing and categorizing various mental diseases and defects. The good old DSM, in its first 2 editions, said that homosexuality was a mental disease. So there is a history here that is not pretty. And I think that we need to think about before we ask judges to be too accepting of neuroscience. Now, having said all that and having thrown out that cold water, Let me say that neuroscience is a much more rigorous body of work than any of the things I just described. But that's not universally true. There are neuroscientists and neuroscientists. One of the most wonderful things about the MacArthur Project is its care in distinguishing this. For example, in the lie detector stuff, it is the MacArthur Foundation that sent in experts to testify that this was not good science and should not be accepted by either the Tennessee court or the New York court. The problem, though, that I see emerging is that the bar has become enamored of neuroscience. This is, Nita referred to this. She was talking about cases between 2004 and 2009. Since then, there's been a considerable further increase in the number of cases in which neuroscientific evidence has been offered. Not always successfully, but it's become a thing that the trial bar has embraced because, as Hank pointed out, you can always get someone to testify to just about anything for the right amount of money. I think we need to look a little more carefully at where this evidence is likely to come in, where it's not likely to come in, where it should come in, and where it perhaps should not come in. One place, and certainly the MacArthur Foundation has been in the forefront of supporting this, is in the area of adolescence, adolescent brains, adolescent brain development. The difficulty there is not, I think, one of phony pseudoscience. I think most of the studies there are really quite good. The problem there is the one that several of our speakers alluded to, which is that it's so far just general evidence, not individualized evidence. In fact, in Roper and Graham, the two cases, one involving the death penalty for juveniles, the other involving life without parole for juveniles, where the Supreme Court in both cases said that it was unconstitutional, I think it's fair to say that the neuroscience evidence was just a make-weight. The court really went off on totally different grounds in making its decision in those cases, but they threw in the neuroscience stuff because they wanted to prove that even Supreme Court justices read something other than the law. And the problem with it is that it is very generalized. So, I mean, what would you do if you had a 12-year-old who committed, say, a theft, but whose prefrontal cortex was already at adult dimensions and all the connections seemed connected up, so he was, if you will, he had already become an adult in neuroscientific terms. Would you really say, okay, we'll take him out of the juvenile court and we'll prosecute him as an adult, even though he's only 12 years old? I think very unlikely you would do that. But in any event, we don't have that evidence. All we have is generalizations, helpful generalizations. I don't mean to minimize them. I'm just trying to point out some of the limitations. The lie detector stuff is a different story. I think that Hank really showed in his presentation, and others had referred to it earlier, that this is a classic example of some good research of a very limited nature that for a buck, two companies have tried to make into something they can sneak into court where it would be entirely bogus. All the studies show basically is that when you're telling what a card actually is, your brain acts one way, and when you're saying something that the card isn't, your brain acts another way. It could be that you're just following directions, not that you're lying in the sense that would make help to the court. Our experience with a polygraph, which is not as scientifically based, but nevertheless should be a cautionary tale. The polygraph has been shown to be wrong approximately 35% of the time. Do you really want to base decisions on an instrument that is that inaccurate? That's why most courts keep it out. I think in some ways the most difficult and most interesting situations will be presented by the MacArthur Foundation's own terrific research under Ken Keel's auspices on determining if you can determine if someone is a psychopath by looking at their brains. It is absolutely true that psychopaths, who are a tiny part of the population, account for something like 30 or 40% of the violent crimes in the United States. So, I mean, this is a population that if we could identify, it would be helpful. But supposing we have a neuromarker for psychopathy, almost surely it's going to have an error rate. It's not going to be a sure thing. Do we lock up the guy who has that neuromarker? Do we give a psychopathy test to all teenagers because it's well known that the only cure for psychopathy is at an early age, and that once psychopaths become adults, there is no known treatment. So do we then, and then if we identify a kid with psychopathy, do we then lock him up? Do we put him into some program even though he's done nothing? On the other hand, if someone has been convicted of a crime and they're a psychopath, instead of giving him 5 years, do we give him 45 years just because he has the neuromarker? These, I think, are very, very difficult questions that the neuroscience fairly raises, but comes very far from answering. So what do I conclude from all this? Hank is always, at the very, very end, the last question stole my thunder, but I'll repeat pretty much what he said. I think the natural inclination of the courts is going to let this stuff in two kinds of situations. One is civil cases. The pain stuff, for example, I think will come in pretty soon in civil cases. An issue in many personal injury cases is the plaintiff says that he or she is suffering from chronic pain from that injury that they realized 5 years ago. Are they shamming or are they telling the truth? Neuroscience may be able to help us on that. But in civil cases, the stakes are not nearly what they are in criminal cases. We're not talking about sending someone away forever. We're not talking about a liberty interest. So I think in the civil cases, it will come in more easily than it does in the criminal cases. And in the criminal cases, I think it will come in more easily, as it already has to some extent, as Nita pointed out, in the sentencing phase rather than in the guilt or innocent phase. Why? Because the rules of evidence are very relaxed at the sentencing phase. A judge looks at almost anything, and also because it's a judge, not a jury. And believe it or not, the legal system is under the belief that judges know something. So with that unproven hypothesis, I thank you very much.